now up.
No problem, Mr. Chairman. Thank you for the recognition. And congratulations, Mr. Park, on your nomination. Welcome to the festive atmosphere of the Senate Judiciary Committee. I know that your family is proud of you. It's a joy to see, as you've been honored with this nomination, your family here with you. And there's been a lively discussion, a long-standing debate that's ongoing about senatorial courtesies and the separation of powers and advice and consent and the blue slips. I'll, of course, reserve judgment on any nominee throughout these proceedings, but I'll just share with you that I've not thus far heard any substantive criticism of you or your record in these proceedings. And I think you've been handling yourself very well. I want to ask you this question, since you just received some relevant questioning from a colleague. Will you faithfully apply the law without bias and without regard for your personal policy or political preferences?
Absolutely, Senator.
And as the Solicitor General for North Carolina, I think as you laid out earlier in this proceeding, you've been called upon to defend legislative clients, the state, on a whole range of cases without regard for your personal policy or political preferences, correct?
That's correct, Senator.
Let's talk about your approach to First Amendment jurisprudence. If you could give us an overview of your perspective on the crucial role that the First Amendment plays in our constitutional system and how you'll approach any First Amendment cases that might come before you, should you be confirmed.
Sure, thank you, Senator. So, as you're aware, there are two broad components to the First Amendment: the religion clauses and the speech clauses, and assembly is baked into that as well. I've had the good fortune to work on a number of First Amendment cases, and on the speech side of the equation as Solicitor General. And this is a increasingly active part of federal constitutional practice. And I am very well aware of the crucial role that the First Amendment plays, both the religion clauses and the speech clauses, to our constitutional fabric.
Based upon your experience, I want to talk about indigent defense, the Sixth Amendment, Gideon v. Wainwright. Based upon your experience in the courtroom, your experience in the law, how vital is it that indigent defendants have counsel, and how will you, should you be confirmed, act to ensure that everybody, regardless of their means, is afforded vigorous representation?
Thank you for that question, Senator. Yes, the Sixth Amendment right to counsel in criminal cases especially is just so crucial for our judicial system to function. Our judicial system is, as you know, an adversarial model where you have two competing sides that are charged with zealously advocating for their clients' interests. It's hard to do that if you don't have counsel. And if you're even an educated layperson, there's a whole set of rules and procedures and technical doctrines that it's just pretty hard for someone who doesn't have legal training to do effectively. And sometimes you see it, and it's amazing, but that is the exception and not the rule. And so if I were fortunate to be confirmed as a judge, I would try to keep the importance of the right to counsel in mind.
And related to the capacity of a party in court to afford counsel is the capacity of a party in court to understand the proceedings. Mm-hmm. In Georgia, we have very diverse matters in the courts and diverse constituencies in court, and language access is a significant issue. I presume that you've encountered or are aware of similar concerns and challenges in North Carolina. What have you seen? What are the challenges faced by parties to civil or criminal proceedings with respect to language access, and how will you, should you be confirmed to this federal judgeship, ensure that parties to your courtroom have full access to the law and to justice, whether or not English is their first language?
Thank you, Senator. Yeah, as the child of immigrants, I am very well aware of the importance of being able to understand the proceedings. When you're in a courtroom, it's often not a friendly experience. It's quite intimidating for someone who doesn't have legal training. And I mean, it's doubly so, triply so, if you have trouble understanding the proceedings because of language issues. One example that comes to mind is I worked on a criminal appeal, a murder in Durham, where the defendant as well as the victims were both undocumented, and there was actually a mistranslation in the 911 call that materially affected some of the legal issues in the case about the accuracy of the description of the perpetrator. So I saw firsthand how important it was for those barriers and access to be overcome. And fortunately, in that case, it was Spanish, and so we were able to identify the inaccuracy in the translation and point that out to the court. But often in less common foreign languages, we might not be able to do that, and so it's just so important.
Thank you, Mr. Park. Thank you, Mr. Chairman.
Senator Hawley.
Thank you, Mr. Chairman. Mr. Park, I'd like to just continue Senator